Hello and welcome. Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo, where we discuss all things estate planning and elder law, and well, hey, anything else we want to talk about. And today's show is going to fall squarely under the estate planning and elder law category. And as we've been trying to do recently, we are actually taking questions from listeners and from sources, that people that are watching us, coming to our workshops, and questions that are coming up, to make it very relevant and to also make it timely. So today's podcast, we are going to be talking about this new revenue ruling that came out by the IRS. And I think there's been some headlines like the IRS quietly is changing inheritance for individuals. And, I had a client a few weeks ago that sent me an email about it, and I was able to respond immediately and explain that the revenue ruling had absolutely nothing to do with the trust that we did for him and his family. And then while I was on vacation, I got some emails from advisors and from some other clients and from even a team member whose mother-in-law saw it and also was wondering if it applied to them. So I thought, all right, in staying with current events and staying up with, everything that's going on around us, and with the revenue ruling, I figured that today's show, we would spend talking about why that revenue ruling has absolutely nothing to do with the types of trusts that we use, and also why I'm not surprised one bit, and that I have been saying this for years. So I want to go back to, probably 2014, 2015. We have been doing professional boot camps in the area in York and Lancaster for professionals such as financial advisors, CPAs, CFPs. So we bring in accountants, we bring in financial advisors, we bring in healthcare professionals, and we educate. We give free credits for them to learn and also to get to know who we are and kind of hopefully be the leaders in the industry as far as education. So as far back as our first boot camp, which I believe was in like 2014, I have been talking about the style of trust that we use at Bellomo Associates. It is called a pure grantor trust. And what that means is that it is, remember, a trust is a contract between three parties, right? So I want to do a little education. It's a contract between three parties. It is a contract between the person who creates it, the grantor, the person who controls it, the trustee, the person who receives it, the beneficiary. That is what a trust is. And the style of trust that we use is an irrevocable grantor trust. And it's a pure irrevocable grantor trust, which means that it is included for the person who creates it, the grantor. It's included for tax purposes for them, and it's also included for estate tax purposes for them, meaning that we want it included in the estate. And just by way of brief kind of background, remember how I feel about the Pennsylvania inheritance tax. It is nothing more than a nuisance. It is a nuisance tax. It is that pimple on your back that is itchy, that maybe even hurts. And then after time it goes away, and then maybe it even comes back, right? But at the end of the day, you don't get hurt by it. It doesn't do anything, and it goes away, and it kind of comes and goes. I truly, truly, truly believe that the inheritance tax is something that is nothing more than a nuisance. And while people get frustrated with it, it is nothing to avoid. And as we have spent tons of time on this show talking about, putting assets in kids' names is not the way to avoid it. In fact, I just did another podcast on it recently, and we've done several before. So please check those out, our radio shows. We have definitely addressed this topic, but that isn't the way to do it. What you want to do is to use a type of trust that we use. Now, the joke that I've been doing in my workshops over the last couple of weeks is that I only mention the word irrevocable once, and then I never use the word again, right? And the reason is because our brains have a way of telling us what the word irrevocable means, or what we think it means, And therefore, our brains shut down. And I've loved it. It went really well. I'm going to continue to do it. I'm going to do it on the rest of this podcast. So I am never going to use that word again for the rest of the show. Okay. We're going to call it an asset protection trust. And the reason we're going to call it an asset protection trust is because if I use that other word, you're going to think it means that you can't change it. You're going to think it means you can't control it. You're going to think it means all kinds of things that it doesn't mean. So by way of a little bit of history, I want to just go back and kind of educate the way that we do in the workshop. Trusts. For most people, we know about trusts from the late 90s. Back then, people who had more than $600,000, and then it went to $1 million, and then I think it was $3 million, but back at the beginning, it was $600,000. If a person had more than $600,000 in their name at the time of their death, the assets that they owned were included for estate tax purposes for federal estate tax. And at that time, they were taxing like 55% tax, 55% tax. So people were trying to avoid this tax. A husband and wife, that was only $1.2 million. So it included life insurance. So people were doing irrevocable life insurance trusts like crazy. People were creating all kinds of things to do to try to avoid it, right? And so the major way are tax trusts, right? They are irrevocable tax trusts. And I'm using the word there intentionally because it means what we think it means in that context. If you were trying to get the stuff in your estate out of your estate for tax purposes, for federal estate tax purposes, the way to do it is essentially to give up control, right? Put it in a trust that you do not control, that you do not have any say over, that you don't have any control over. You cannot change the terms of the document. Now, again, back then, people with $1.2 million needed to do this. Nowadays, the current is $12.92 million plus $12.92 million. So let's just call it $26 million. There are very few people in the area that have that kind of wealth. And if they do, they're probably working with large Philadelphia law firms to get their complex high-end estate planning done. I am not embarrassed to say that I have 0 clients that have more than $26 million. That is not the clientele that I am going after. That is not who we are spending our time trying to assist. Yes, I have a master's in taxation. Yes, we could. Certainly that part isn't the issue. But that is just not the focus of our practice because there isn't enough people that we could service to be able to make that the focus of our practice. So we are not concerned about that. And because we are not concerned about that, as I have said on other shows, I want the assets to be included in the estate. I want the step up in basis for the children and grandchildren, okay? So just a quick lesson, just a quick review. If a parent puts their child's names on the assets, the child now gets the basis of the parent. So if the parent has a house and they paid $20,000 for it, we're just going to avoid depreciation and all other complex tax stuff for now. And we're just going to say that the basis that the parent has is 20 grand. If they put the child's name on that property, as long as it's in the child's name for more than a year, they'll avoid the Pennsylvania inheritance tax. And as long as it's in the child's name for more than 5 years, it will not be subject to the look-back period for Medicaid purposes. But as I have said on numerous shows and every workshop, that in most cases is a horrible, horrible, horrible idea. A gift is a 4-letter word, right? It is a bad word. If you're getting advice from a professional, a financial advisor, an accountant, an elder law attorney, and they do this all the time, and they advise you on the complications or implications of what would happen if you ended up needing long-term care, or if a child or grandchild ended up getting divorced, nursing home, car accident, or if the grandchild just kicked you out of the house, And if you're also being taught about how the child does not get the step up in basis unless they live in the house for 2 out of 5 years as their primary residence. In most cases, children do not live in that house as the primary residence because they have their own houses with their own families, and therefore they're not living there. But just assuming that the professionals that are talking to you are telling you to put the kids' names on everything, if they're giving you the implications, as I used to do for years, we had a workshop for years called the 3 lands to your family's security, and I would run around the room talking about tax land versus long-term care land versus estate planning land. If the people are talking about the implications and you still think it's a good idea, by all means, buyer beware, as I learned in law school, caveat emptor. But as long as you're being educated and understand the implications, I have no problem with the ultimate decision. As I always say, when you do something with a professional and you make a decision based upon the facts as you know them the day that you are making that decision, and as long as you fully understand the implications, I don't second guess professionals anymore. Where I second guess is when they're not fully educating people on the implications, which is why I love that 3 land workshop, because I would literally run around the room saying, okay, this is what happens if you're making the decision from a tax perspective. This is what happens if you're making the decision from a long-term care perspective. This is what happens if you're making the decision from an estate planning perspective. And they're all different. Every implication is different. So in one of those lands, any decision that you make is going to be bad because they're actually all counterintuitive. They're different, right? It's like physics. For every action, there's an equal and opposite reaction. In estate planning and elder law, for every decision, there's an equal and opposite decision depending on what the circumstances and the facts turn out to be. If the person ends up in the long-term care situation, if the person ends up in a car accident, in a divorce, ends up losing a job. I mean, there's so many things that are outside the control of people that's what the decision ultimately will determine or be the outcome if it was a good decision or not. So all of that to say, if you're getting that advice and you've been understanding the implications, by all means, make the decision that's right for you and your family. But on this podcast, I'm urging you not to be doing that, right? The trusts that we are using are irrevocable, not going to use the word, pure grantor trusts. And why that's significant is because it is included for income tax purposes, which is a good thing, and estate tax purposes, which is a good thing. And the reason for that is because in most cases, the parent or grandparent wants to take the burden of the tax consequence for the family, right? Overall, they're trying to help the family from a tax standpoint, but also get the asset protected. And because we don't have the situation where there are many people that have more than 12.92 and 12.92 million if they're married, we are not worried about getting taxes out of the federal estate. And yes, I do know and I do understand that in 2026, we're looking at it coming back to $6 million apiece. So $6 million if you're single, and then another $6 million if you're married, for $12 million if it's a married couple. That is set to go to 5 plus inflation, so we're just kind of basing that on the inflation rates and where we are. It's going to be right around that. But again, the majority of the clients that we are representing, they don't have more than 12 million as a couple. And some have more than 6 million as a single individual. And there are tax planning things that we can do. I do have a master's in tax. I am able to play that game and I do understand it. But for the majority of the clients, that is just not applicable. Okay? It just doesn't apply and it won't. So we don't want to get ourselves in a situation where we're doing things and giving up control, giving up the ability to change the document. Now, the purpose of this show is not to get into the trust in detail. We have done that on numerous other radio shows, podcasts. We've done it in every workshop. If you're looking for more of the how-tos of the trust, please come to a workshop. Please watch those podcasts. The purpose of this specific podcast is, as we were doing those boot camps early on, and I was explaining the style of trust that we had been using and that people all over the country were using, and that I was educating attorneys all over the country on as I was traveling the country teaching lawyers this style of trust. What I kept saying was, this is not an intentionally defective grantor trust. This is not a domestic asset protection trust. And I would go into grave detail in these boot camps explaining that those are two styles of trust that I have never once drafted, that I have never once used, and the revenue ruling that came out recently was only in regards to an intentionally defective grantor trust. Now remember, the trust that we're using is a pure grantor trust, which means it is included for income tax and estate tax purposes. The intentionally defective grantor trust that the revenue ruling talks about is about a trust that was created, which I still don't understand how it worked. I still don't know how they got away with it. So when this revenue ruling came out, I wasn't surprised at all because it violated basic tenets of just estate tax law. It had it so that it was included for income tax purpose. So it had provisions in the document that made it included for income tax purposes, but not for estate tax purposes. Now, what the significance of that was that people were able to do intentionally defective trusts, have it not included for estate tax purposes, but somehow they were able to get a step up in basis so that when the asset was transferred then to the children, they were able to get this step up. And I have been saying since 2014, this makes no sense. It defies logic. It defies the rules of estate. The reason that our trusts are different is because our grantors have complete control, right? They are in control. If you go in and watch those shows that we've done on how the trust works, they can change the document. They can change the terms of the document. Yes, they can't give it directly back to themselves, but that's it. So for us, it is included for income and estate tax purposes. And yes, they get a step up in basis. This revenue ruling essentially says, for people who are doing intentionally defective grantor trusts, where it's included for income tax but not estate tax, they don't get the step up in basis, meaning the children don't get the step up in basis. Why? Because the parent didn't control it for estate tax purposes. That's the definition. I don't know how they ever did. And I've been saying that since 2014. A very close financial professional that I've been working with and who I believe was actually in the room that day, who emailed and asked questions about, hey, I know you've been doing a lot of stuff publicly and on your shows about irrevocable trusts. You may want to spend a few minutes explaining this revenue ruling and why it does not apply. And then when I kind of responded and did a little brief synopsis, he replied back and said, yeah, I remember you talking about that years ago in these boot camps, and I just didn't understand how people got away with it. And the truth is, I don't either. And one of the things that I have been saying is the reason that I have stayed away from domestic asset protection trusts and intentionally defective grantor trusts is because they defy the rules. They defy simple tax, just straight up logic. And for some reason, there's an exception carved out. I don't know why there was an exception carved out, but anytime that there's an exception carved out, you have to assume that that exception may be taken away. The trusts that we are using are not exceptions. They are very, very basic trust principles. They are included for income tax and for estate tax. Therefore, and it's all because of control. We meet the definition, we meet the estate tax rule definitions. And if we were in a situation where we had a family that had the kind of wealth that we were trying to avoid the estate tax situation, that have more than 12.92 and more than 12.92, we would not be using an intentionally defective grantor trust in my practice. We would be using a pure irrevocable tax trust where the person does give up control, where the person does have to pay higher trust tax rates, where the person can't change it, where the person can't have a say or ownership over it, where a person can't just give it back to themselves. But I'm not going to be using an exception to the rule, hoping that they don't change it later. That is not the type of practice. We stay well within very, very safe, true principles. And that is why the revenue ruling 2023, this year that came out, does not apply to the trusts that we have been creating and have done for the last 14, 15 years, very consistently with great success, 100% success, and the tax consequences that we are expecting it to have. And again, it's just very simple, basic principles. The intentionally defective grantor trust that the ruling is talking about was an exception that was made to allow people to create an irrevocable trust, have it included for income tax purposes, but not estate tax purposes, and then somehow get a step up in basis. This revenue ruling said, no, if it's not included for the estate tax purposes, you cannot get a step up in basis. Now, my problem with the articles that are coming out is that the people who are writing them as if it was very common practice to write intentionally defective grantor trusts. And you know what? For people who are working with people that have more than $26 million, yeah, it probably was. But again, what is the percentage of people in Pennsylvania, in York and Lancaster, that have more than 26 million? And the answer is not many, right? And again, if there are, and there are, they're not probably working with local attorneys. They're working with Philadelphia attorneys. They're working with people who are working with people with hundreds of millions of dollars so that they're getting the top end, high end planning. They're probably not working with attorneys in York and Lancaster simply because it is so complicated. And I have a master's in tax and I know where to stay in my lane. So the purpose of this show today was really to hone in on the fact that if you hear anything about the IRS quietly changing the rules of inheritance tax and the IRS ending the ability for parents to give houses and getting a step up in basis in an irrevocable trust, that is an intentionally defective grantor trust. That is not the trust that we use in our office. We never have, not even one time in the history of this firm. And it is also not a domestic asset protection trust. I have been really careful to not use the word, you know what it is, when I'm teaching now, because I see people's brains turn off when they hear that word, because the trust we are using do allow them to change the terms, do allow them to change who gets it, when they get it, how they get it, does allow them to have it in their income tax individual rates, does allow them to change it, does allow it to be included in the estate, does allow the children to get a step up in basis. So again, the revenue ruling that came out this year does not apply to the pure grantor trust that we are using. Pure meaning it's included for income and estate tax purposes. It only applies to intentionally defective grantor trusts, which was an animal that was created to somehow be included for income but not estate, and they still got to step up in basis, which makes no sense. It never did. They never should have been allowed to do that, but the IRS came down this year and said, nope, we're not allowing it. So if you're reading any articles or any podcasts about how the IRS just changed the ability to use irrevocable trust, not true, not true, not true, not true. Not what we are using in our law firm. It was a specific type of irrevocable trust that does not apply to the people that we are working with, does not apply because our people do not have more than the federal estate tax limit, which is currently $12.92 million plus $12.92 million if they're married. That is $26 million, not a problem we are having. So we are good to go with the trust that we are using. Again, it's based upon common law principles, not exceptions to a rule. And it is not a domestic asset protection trust, and it is not an intentionally defective grantor trust. It is a pure grantor trust. If you'd like to learn more about these types of trusts, please come to one of our workshops, check out our podcasts, check out our radio shows. We have all kinds of opportunities for you to be able to learn a lot more about the trust that we use. It does allow us to get the best of all worlds, but also stay well within common law principles that are very, very settled and that we feel very comfortable that we are good. So again, that revenue ruling that came out this year has nothing to do with the irrevocable trust that we use in our office. It is an animal that was created that we never used, and it has nothing to do with it. So thank you to the financial professionals who reached out. Thank you to the clients who reached out. And thank you to the listeners of this radio show who reached out and also were wondering if it was going to end the ability to do what we're doing. Nope, has nothing to do with it. Didn't change anything we do, and we are still good to go. So please check us out at Bellomo Associates, 717-845-5390. That's 717-845-5390. Or check us out on the web at www.bellomoassociates.com. Please come to one of our weekly workshops. We have workshops in York and Lancaster, estate planning, Medicaid crisis planning. We even have a special needs workshop as well as a probate and trust administration workshop to let the executors and trustees know about what has to be done and what to expect when a family member passes away and they are responsible. Check out the new office in Lancaster at 1755 Oregon Pike, right behind Eden Resort, right behind the Sheets in that office complex. We hope to see you at the office. And again, thanks for attending and listening to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo. And on this podcast, we talked all about why the revenue ruling does not apply to the trust that we use. If you have any questions, please reach out to us. And until next time, we'll see you real soon.